My name is Beverley Flynn and I head up data protection, cybersecurity and privacy at law firm Stevens & Bolton. I actually started doing data protection pre-1998, so I've done the 1984 Act, the 1998 Act, and more recently the 2018 GDPR. I've been asked today to talk about future changes, which I am going to do, but I thought first of all I'd just give you a brief overview of the agenda in case there's anything that kind of tickles your fancy, and then we can chat about anything afterwards if you've got any specific questions. So I'm going to talk first of all about DPID. Steve was really keen that I spend some time on DPID. Not my favourite topic, and you'll see why. And then I'm going to talk about cookies, because I love cookies, and they're not the chocolate kind. You can't really do a talk at the moment without mentioning AI, slightly on point. I'm going to give you some helpful guidance, talk about some fines, just to give you a bit of fear. Talk about the international data transfers, an interesting and questionable regime. Then give you some actions to think about, and then a little bit of horizon scanning. And it was interesting you talking about IoTs, because the future legislation is all about IoTs and cybersecurity. So it's really kind of gels quite well. So first of all, just a little bit of a test. Don't worry, not going to embarrass anyone in the room. But does anybody here, or has anyone here heard of the UK GDPR? I can see a fair few nods. There is, in fact, the UK GDPR, and since the delights of Brexit, we have the EU GDPR. And what we have at present is a divergence, and that divergence is getting stronger and larger. So once upon a time, when the GDPR came into play in 2018, we had a level playing field across Europe. Now, thanks to Brexit, our position is differing. So sometimes it's worthwhile just deciding, am I looking to work with the UK GDPR and the EU GDPR, or the UK GDPR or the EU GDPR? I'm also going to talk a little bit about the PECRs. I don't know if anybody knows the PECRs, but it's a piece of legislation that sits hand in hand with the GDPR. It's the Privacy and Electronic Communications Regulations 2003. Doesn't it roll off the tongue? And I'm also just going to do a little bit about personal data as well, just so you've got the context, because today you were talking about data as a whole. This is a small subset of data as a whole. It's only personal data. So data to which you can identify a living individual. So if you're dead, this legislation does not apply to you or to whoever you're talking about. We have three concepts just that I thought would be helpful and help you put it in context. The UK GDPR applies to data controllers. Are any of you employees? Yeah. Do any of you work for a company? That company will be a data controller in respect of your personal data as an employee, because that company will process your name, your date of birth, your address, your NI number. So that company is a data controller and is covered by the UK GDPR. You, as the employee, are a data subject, and you are the subject in respect of which the personal data is processed. Processing does not mean to say you have to do anything with the data. Simply holding the data in the cloud is enough for the GDPR to apply. We don't actually have to manipulate it or make use of it. That's a common fallacy. And then finally, if your company, for example, outsources your payroll to a third party, that payroll provider will be potentially a data processor. That data processor used to be known as a computer bureau many years ago, is now known as a data processor, and it will also be subject to the requirements of the GDPR. And that was actually the biggest change as a result of the 2018 legislation. In the past, the controller only was subject to the regime. Now, the controller and the processor, so the outsource provider, the IT provider, the IT hoster, the payroll provider, all of your outsourced providers are also subject to GDPR. And that was actually, despite all the rigmarole, the biggest change. So, DPID, you made a reference to it, and I'm going to comment about DPID at the end, because you can tell me whether or not you think it's a good thing. I'll have a show of hands at the end. So I talked about this divergence in the legislation. We've got the EU and we've got the UK. This is the UK making the environment in which you can use and work with personal data much more accessible to businesses. So it will protect individuals less, but it will accelerate and enable businesses to do more with personal data. It's been renamed 3 times. It was the rolls off the tongue Data Protection Digital Information brackets number 2 bill, and it's now just known as DPID. What does it do? Well, it does a lot, actually. The first thing it does is narrow the definition of personal data. So that helps you to make more use of personal data because the restrictions and the protections of the GDPR don't apply to quite as wide an ambit of personal data. And just so you're aware, do you think your name is personal data? I'm going to see a lot of nods in the audience. What about your national insurance number? It's just a number. Is it personal data? Yep. How about your IP address? It's just an IP address. Yep, it's personal data. So it's quite surprising what is personal data. There's a subset of personal data which attracts special protection, rather imaginatively called special data. Special data is data which is, for example, ethnicity, trade union membership, political views, medical health, those kind of really special data that need to be protected. Now, does anyone here have financial data? Yeah. Financial data is not special data. It is actually doesn't have enhanced protection under the GDPR. So just bear that in mind when you've got a breach. So personal data is going to be narrowed. Has anybody heard of a data subject access request? Yeah. Has anyone made a data subject access request? Has anyone received a data subject access request? Looks like Steve's done a few. Yes, well, I often get involved in data subject access requests, and they come in all sorts of guises. Interestingly enough, they don't need to be in writing. They can be made over the telephone, and it's sometimes quite hard for businesses to appreciate or realise that they have actually had a data subject access request made against them. If you do receive one, you have to act within 30 days at the latest, promptly in 30 days at the latest, and they are quite they're very useful for individuals, and I completely go with them, but they can actually be very troublesome for a business if it's faced with a fair number of data subject access requests. Now, the current rules say that you can sometimes avoid responding to a data subject access request if it is manifestly unfair or excessive. I'll show you some guidance at the end. If you can get into the guidance on what's manifestly unfair and excessive, it can be quite challenging to actually resist the data subject access request. So what DPID is doing is actually introducing a new concept of vexatious DSARs. And if a DSAR or data subject access request is vexatious, then actually you may be able to resist having to respond to it in full form. So again, a useful tool may be in the UK. Now, when you're processing data, remember that simply means holding it. It doesn't have to actually do anything with the data. You have to have 2 things. You have to have a legal ground for processing that data, and there are 6 legal grounds. If it's special data, do you remember we talked about trade union membership, political views, medical health? not only do you have to have one of those 6 legal grounds, you also have to have an Article 9 condition of processing. Again, rolls off the tongue. Now, one of the legal grounds that everybody's aware of for processing personal data is consent. And probably, you consent every time you go on a website to something or other. Now, there are other legal grounds for processing personal data, and one of the reasons why businesses try not to rely on consent is, 1, it has to be freely given, and 2, it can be withdrawn at any moment. So if that consent is withdrawn, can you imagine? All of a sudden you've got to remove that data from that IT system. So what businesses try to do is rely on one of the other 5 grounds for processing personal data. And one of the best legal grounds for businesses is known as legitimate interest. Now, it's really difficult to know sometimes, is it or isn't it legitimate interest to use this data in this way? And so what the legislation currently requires is that you do a balancing test and you fill out a form. It's called a legitimate interest assessment. We call it an LIA. And then you decide whether or not the legal ground you're relying on is legitimate interest. If you read your employee privacy notice that you all received when you signed up to be an employee, you'll see loads of legitimate interests in there. What the difficulty is for us all is assessing, well, is it really legitimate? Is it justified? And so what the legislation is doing is it's actually deeming that some specific processing counts as legitimate interests, and so you don't need to worry about weighing up all the pros and cons. And one of those is actually using the personal data within a group. Data protection legislation is blind to group companies. It looks at the company that took the data and only looks at that company only. So unless you've got a legal ground to transfer your employee data or any business data which contains personal data to another group company, actually, why should you? Why should your employee data go to the US, to the parent company? Well, it may be legitimate to do so because actually they're going to assess your bonus. So what the new legislation will do will give us some deemed legitimate interests. And they will include, if it comes in, some forms of direct marketing. So actually, rather than relying on consent in certain circumstances, we may be able to rely on legitimate interests. Transferring personal data intergroup, that's a really big thing at the moment. I do lots of intergroup data transfer agreements, trying to justify transferring the personal data around the group as a whole. And also, it's going to change the cookies laws. I'll come on to cookies in a minute, but if it does change cookies laws, which don't rely always on legitimate interests, they rely on the legal ground of consent, it's going to say that for statistical and analytical cookies, you don't need consent. And actually, that will be an enormous change. It will be really helpful if we don't need consent for statistical and analytical cookies. Now, you've probably heard of someone called a data protection officer. I happen to be the one for our law firm. Anybody? I know, B, you're here and you work in our compliance team and you do a lot of that with me. In most companies, there'll be a data protection officer, or there'll be somebody who's responsible for data protection. That's going to change under the UK requirements, and we'll have I think it's something like a superior person or a single person or something. It's going to have a funny name, but actually they're not going to be much different to a DPO. They're just not going to be called a DPO. We've also, since Brexit, required to have representatives. So, and these are different to DPOs, so if you don't know whether or not you've got a representative, you might want to look into it. But if you are processing personal data about UK individuals and you are not established in the UK, then you need to appoint a UK representative. If you've got a UK company or a branch, you don't need to worry. And likewise, if you're processing personal data about someone in the EU and you're not established in the EU, you have to appoint an EU representative. And that's so they can the supervisory authority in the UK, the supervisory authority is the ICO. That's so they've got someone who they can go to when you're not incorporated or you're not really based in that, established in the territory. Now, this legislation will dispense with the requirement for a UK representative. Again, that helps businesses. I don't know whether or not it really helps individuals because there won't be anyone to go to in the event of a problem. And I mentioned cookies consents. For analytical and statistical cookies, we will no longer require consent because they will deem that to be appropriate. So actually, the bill, the BIPID, that's only a few of the things. I've got a slide as long as my arm, and I don't want to bore you with loads of legislation on an evening. But there is quite a lot of change coming. Now, we have to decide in our positions as individuals, is that good? And then in our positions as business, is that good? And then we have to think, well, it does change it for the UK environment, but these days, how many businesses only operate in the UK? If your business operates in the EU or uses personal data, processes personal data of individuals in the EU, you're probably still going to have to comply with the EU GDPR. So back to my original slide, you'll comply with this lesser obligation under the UK, but in order to meet the higher obligation under the EU, you're probably going to end up working with the higher obligation anyway. So some might say, and if you read the commentary very carefully on DPID, it's seen as slightly Britain after Brexit and we are more liberal, but in practice, it probably means that we'll have a lower threshold here. We may lose our adequacy status in order to transfer personal data from the EU into the UK. And we're still going to have to comply with the EU thresholds anyway. So, does it really help? Cookies. I don't know if any of you have noticed, but there has been a real great increase in enforcement action by the ICO, the Information Commissioner's Office, on the use of cookies. I hope you all have noticed that there are probably, or in the old days, there used to be little banners on websites or on a device or on your TV when you're going to log on, and there'll be cookies there and it says if you continue, you'll be deemed to have accepted these cookies. If you go on a website or anywhere where it says that, that is no longer the law, and you'll know immediately that that website or that device is out of date. What you now have to do is have actual consent, and you have to tick consent to using the cookies. And on top of that, what you also have to have is a reject all button. And the ICO is sending letters to businesses as it looks at their websites and goes on their devices and asking businesses to complete a form. And that, if you receive that form, that's a warning they're watching you, and probably you need to update your cookies approach. So cookies are changing. The law changed a little while ago and it's evolving, but at present, check the cookies on your website. You don't need consent to necessary cookies, strictly necessary cookies. What is strictly necessary? Slightly open to interpretation, maybe. As I said, you can't really do a talk on data protection without talking a little bit about AI. Yes, AI. What do we do about AI? What do we do with AI? Well, the first thing to do is to look at the terms and conditions that are applicable to its use. And I think you will probably find there'll be terms and conditions, and actually in the last 6 months it's improved incredibly. There are now some privacy notices. At the beginning there weren't any privacy notices. But you'll find terms and conditions and privacy notices. And it's actually quite important to read those before you upload or you input a load of data, including personal data, because One, it may actually say that the governing law for the use is actually not English law. It may also submit you to the jurisdiction of the US courts. In fact, a lot do. And it may also allow them to make use of the data that you've just inputted. And if you are comfortable with that, that's fine. But if you are not comfortable with that, and there may be some reasons why you're not comfortable with that, because it's personal data, you may be breaching confidentiality obligations, you may not have one of those legal grounds for processing, or if you're relying on legitimate interests, you need to have done an LIA, and you need to make sure it was in your privacy notice at the time that you were going to be using this AI, and this is the purpose you were using it for. And you may find that you've actually breached your obligation not to use the data any further than you should have done in the first place. So there's quite a lot to think about just in terms of terms and conditions before you even think about data protection. Now, the ICO, the Information Commissioner, has kindly put on their website a little toolkit for when you're thinking about AI. So I would recommend that to you if you are looking at using AI. And what that deals with is quite a few things. First of all, you have to think about a legal ground for processing. We've already been through that today. If it's special data, you also have to have one of these Article 9 conditions for processing. If you are using legitimate interests, is it in your privacy notice? Is your privacy notice up to date? Have you updated your Article 30 ROPA? You were just talking about the legal register. I don't know if many of you are aware, but Article 30 of the UK GDPR and the EU GDPR requires that you have what's known as a ROPA, a record of processing activities. It's really detailed. You would want to have that on there. Also, if it's a new type of processing, because it's either new technology or a new way in which the business is going to be using that personal data, it's where you have to undertake what's known as a DPIA. There's lots of acronyms in data protection. It's a data privacy impact assessment. And that, again, there's an example on the ICO. It's not completed, but it gives you the headings of what you need to think about. So if you were to go to the ICO's website, you could find an LIA, a legitimate interest assessment pro forma. You could find an Article 30 ROPA, a record of processing, and you could also find a draft DPIA. They won't be completed, but they tell you what you need to do from a UK data protection perspective. Now, going back to privacy by design, you also have to think about Article 25 of the UK GDPR, which is designing your whole privacy programme to minimise the use of personal data and to make sure that personal data is used only for the authorised purposes with appropriate security, Article 33 et al. So when you choose your AI option, just make sure you've gone through that thought process. I just want to mention automated processing. There are specific rules under the UK GDPR about profiling or automated processing of personal data without any human interaction. I won't go into them now. The ICO toolkit tells you a little bit about them. But you wouldn't want to profile people or profile individuals, and you definitely wouldn't want to just use the AI without any human interaction, or else you come into lots of other issues that you need to think about. I've already mentioned the onward use of the personal data, and really this applies not just to personal data, but to data as a whole. I know I'm talking about the subset of personal data. But if you do allow that personal data or that data to be used onwards, just think about whether or not you've breached a restriction or an implied term. And finally, back to my start of the talk, think about confidentiality. Are you breaching confidentiality? And remember, there are two levels of confidentiality. There may be a contractual confidentiality clause in your contract, but there may also be an implied common law duty of confidentiality if there's not a contractual obligation of confidentiality in your contract. So it's actually quite a lot to think about before you just merrily go off using AI. I said that there's lots of guidance, and this is an example of the guidance from the ICO. This week, the ICO issued, as well as we've got the AI toolkit, it issued a consultation on the use of AI in the context of personal data. So if you are thinking of using it, I would read that consultation, because the consultation often tells you the difficulties and the barriers in order to find out what the right answers are. So actually, it's really helpful. The guidance gets updated all the time. I've just put some examples there to give you a flavour, really, and how helpful it is. I mean, you do have to wade through it, and it's quite technical at points, but it's really helpful. Now, I've talked mainly about the UK, but I just wanted to gently touch on the EU. First of all, each country has its own regulator. So over here, we have the ICO. For example, in France, they have the CNIL. In Italy, they also have a supervisory authority, and that was the first supervisory authority to come out with a view on AI, which was actually, quite brave. The CNIL, the French one, issues a lot of guidance on cookies. So sometimes it's worth looking at what the other regulators say. The Irish one is another one that issues quite a lot of guidance, because it's slightly caught, because, as you can imagine, all the large tech companies are headquartered in Ireland. So sometimes the UK one has a more robust approach, shall we say. This is the EDPB, European, again, another acronym, apologies, European Data Protection Board. And this issues guidance across the whole of the EU GDPR. And it's really helpful. It's just issued some guidance on fines. So it's quite helpful, I find. It's just knowing where to find it. Speaking of fines, just to scare you a little bit, now we've Brexited, we have fines under the UK GDPR. You can see what they are, the higher of. And on top of that, there's the potential for fines under the EU GDPR, which are more or less the equivalent. And on top of that, we've got those PCRs that I spoke about, the Privacy and Electronic Communications Regulations. They too allow for fines. So you've kind of got 3 bites at the cherry for being fined. And on top of that, that's separate to a compensation claim by an individual if they wish to bring a compensation claim. I've put 3 examples on here just to give you a flavour, and maybe a little bit of background just so that you understand the context. Interserve was a cyber attack, and the reason why it got a really high fine was probably twofold. One, it had not been maintaining its system, so it actually, it was in the status quo scenario, hadn't been updating, maintaining, putting money into looking after its system. And secondly, it had policies and procedures, but was not seen to be adhering to them, implementing them, or abiding by them. So it was on paper, but not in practice, just a Sharon's point. Halfords, this happened during lockdown. The Privacy and Electronic Communications Regulations, which everyone always forgets about because they're so busy focusing on the UK GDPR, actually deal with electronic marketing on top of cookies. And they prohibit unsolicited marketing. So if somebody has opted out, you're not allowed to email them with any marketing messages. And here, Halfords tried to claim that their message about bikes during recovering some costs during COVID was a service message, not a marketing message. The ICO did not agree and decided it was a marketing message, and therefore it sent it to people who'd opted out, and therefore it got levied. And then TikTok. I'm sure many of you have heard of TikTok, have access to TikTok, have children who have access to TikTok. And as a result of TikTok maybe not quite taking on board that children under 13 need to have special considerations when you're talking about collecting their personal data and using it around the world, was fined 12.7 million. has revisited considerably its onboarding processes. And as a result of that, we also now have the Children's Code. So I was doing a platform for a charitable client which has children that are hindered in some way. And halfway through implementing the platform, we also had to take account of the new Children's Code. So a good thing for children, a challenge for businesses. But it's thanks to TikTok that we now have that. I want to talk something counterintuitive. Well, it certainly is to me, and you may well have heard of it. There is this basic concept, both in the UK and in the EU, that it's prohibited to transfer personal data, in the case of the UK, outside the UK, unless you come within one of those three scenarios. Now, in this global society, that feels really counterintuitive, doesn't it? Well, it does to me anyway. You know, why can't I use a payroll provider outside of the UK? Because we know that there are payroll providers all hub together in one country and have a real centre of excellence. Well, no, we're not allowed to do that unless we comply with one of these three requirements. So the basic proposition for us now we've Brexited is that if we want to transfer personal data, say host it, use an IT provider, use a payroll provider outside the UK, we need to do it in a country where there is either an adequacy decision, there are safeguards in place, or a derogation applies, an exception applies. Now, the exceptions are rarely used. If you go to Article 49 and look at the exceptions and look at the guidance from the ICO, there really are one-offs. So relying on a derogation is the last bolt of the brigand, as one might say. And we really look at adequacy decisions or safeguards. So adequacy decisions, you'll be pleased to know 2 days ago, Europe confirmed that it sees the UK as adequate still. If we introduce DPID, I don't know. But currently, we can transfer personal data to Europe. There will come a time when it may say we're not adequate, and all of a sudden we'll be like, oh, what do we do? So as privacy lawyers, we hold our breath every time the adequacy decisions or the law changes, because it's open to everyone else to reassess our privacy laws and decide we're no longer adequate. If you're in IT and you're buying in cloud space, servers, etc., you'll often be charged a little bit more for it to be hosted either in Europe or in the UK. Pay it. Because if it's hosted in the UK, you don't have to worry about this transfers abroad point. If it's hosted in Europe, you can not worry about it for the moment, but it may come a time when you may need to worry about it. If it's hosted in a third country outside of Europe, you need to go to number 2, the safeguards, if it's not a whitelisted country under an adequacy decision. There are fair few countries that are whitelisted. You may be surprised or not surprised to know that US is not listed as adequate. It's something to do with the fact that their security, I won't say their homeland security can look at your personal data and has rights to look at your personal data. So it's not seen as adequate. So what do we do about that? Well, the US, has anyone heard of a gentleman called Max Schrems? Great, interesting, really interesting character, done a lot for privacy, thank you. He listened to Facebook and realised that Facebook had little regard for privacy and use of personal data. And so he runs an association and helps challenge when he thinks that privacy is not going well. And one of his challenges is him and now a French MP are challenging the third set of transfer mechanisms for us to be able to transfer personal data to the US. So if you're currently relying on what was Privacy Harbor, Privacy Framework, and is now the Privacy Bridge to transfer personal data to the US, any person worth their salt will also insist that you use some of those safeguards on top, just in case the privacy bridge is challenged. And in order to make use of the privacy bridge, you have to make sure that the entity in the US is signed up to it and it's for the type of personal data that you are transferring. I'll come on to some other things in a minute. So how do we deal with transfers of personal data abroad, and why do you get faced with all of these bizarre documents that are called Article 28 clauses, data protection agreements, DPAs, and model clauses, SCCs, the UK addendum, and the International Data Transfer Agreement? Why do you get faced with all of that? Well, there's two reasons, really. If you're using a third-party provider to host your data, your company is the controller and the provider is a processor. Do you remember at the beginning we talked about data controllers and data processors? A data controller and a data processor have to have what's known as a data processing agreement in place, which is required by Article 28 of the UK GDPR and also Article 28 of the EU GDPR. So you have to have that data processing agreement in place with any processor. And on top of that, you need to make sure if that processor is outside the UK or if it's a controller-to-controller transfer, even inter-group, that you have got some safeguards in place. And the easiest safeguards are binding corporate rules. Only the really large organisations use binding corporate rules. They're not for the day-to-day smaller business. Codes of conduct or certification, again, not really tried and tested at this stage. So we're only left with standard model clauses. When a few months ago, the standard model clauses were changed by the EU, because we've Brexited, we cannot, as the UK, rely on the standard model clauses of the EU. We've had to introduce something called the UK addendum. So if you wish to rely on the EU standard clauses, you need to update them with the UK addendum. It's the second document. If you don't wish to rely on the EU standard clauses, you can instead rely on item C, which is called an IDTA, another acronym, an International Data Transfer Agreement. But most businesses, because they have some relationship, or they may be transferring data outside the EU as well as outside the UK, tend to go for A, the standard EU model clauses with the UK addendum. That is a lot of paperwork. It really is. So if you're transferring personal data abroad at the moment and you've been relying on the old model EU SCCs, you probably need to update them to add the UK addendum, or you need it to enter into a UK International Data Transfer Agreement. When I look at anybody's website, I can immediately tell whether or not they're up to date on data protection, because if their international transfers clause is incorrect, I will know immediately they haven't taken account of that. On top of that, you need to update your Article 30 record of processing, because now you need to differentiate between transfers outside the UK and transfers outside the EU. Once upon a time, it didn't matter. And you also need to add all your processors to that Article 30 ROPA. You'll also need to update your standard terms and conditions to take account of international transfers. And you'll also need to update your cookies policy. There's a little summary. Do you need a representative? Is your terminology up to date in your privacy notice, in your Article 28 data processing agreements, in your standard terms and conditions, and on your website? Have you revisited your transfers abroad? And are your cookies banners correct these days? Last but by no means least, a little bit of horizon scanning. IoTs. That's the EU equivalent for IoTs in the future. It's about making sure that that nanny cam, that Ring doorbell, that whatever you use, is future-proofed from a cyber risk perspective. It's about registers, it's about manufacturers, it's about distributors, it's about those who are importing. And those first two deal with that. The next two are EU pieces of legislation, not UK, but just to be aware, on the horizon is a right for you to see analytics that currently only probably manufacturers or businesses use in products, and there will be a right in the future for individuals to see those analytics. And currently some businesses use those analytics to make money and to sell on, so when all the users can ask for them, that's going to be quite a big change.